It is difficult for women to successfully demonstrate gender bias and denial of equal protection of the law in the governance arena, because more often than not, these biases and discriminatory treatments are not brought out starkly by those who perpetrate them, but rather they are subtle yet significant actions, decisions, and omissions that create an unequal playing field for women. That being said, the petitioner and the second interested party have not particularized this complaint with specific reference to the Senate's proceedings or shown an aspect or element of the proceedings before the Senate that show gender bias against the petitioner. Perhaps this is because, while we have a wider problem with gender bias, the Senate conducted its proceedings strictly without any form of gender bias against the petitioner. Had the contrary been demonstrated to the required standard, then on this sub-issue of 7 main issues, this court would have had no hesitation in quashing the Senate's resolution. The final claims raised by the petitioner relate to the dating of the Gazette notice and the clerk of the Senate's letter, as well as the speed with which the Senate conducted the impeachment vote. The Senate contends that the Gazette notice and the clerk's letter were both dated 20th August 2024, despite the vote taking place on 21st August 2024, which she argues is a proof of a predetermined decision. Under Section 107 of the Evidence Act, the burden of proof is on the petitioner to establish that these documents indicate a premeditated decision rather than being the result of a typographical or clerical error or even a good faith mistake. The petitioner failed to provide evidence to refute the simpler explanation that the date discrepancy was a minor administrative oversight rather than the much more serious claim of a proof of a rigged or predetermined process. Similarly, the claim that the Senate rushed to conclude the impeachment or sat on non-gazetted days has not met the required threshold, as there is no requirement that the impeachment proceedings must last a specific duration. Courts have previously held that the expedited process is not inherently unconstitutional unless it is demonstrated that it deprived a party of an opportunity to be heard. In Republic versus Speaker of Nairobi City County Assembly and another ex parte Evans Kidero, 2017, the court held that an expedited process is not inherently unconstitutional unless it is shown that it deprived a party of an opportunity to be heard. The petitioner has not demonstrated how the Senate's action of expediting the hearing and determination of the matter before it deprived her of an opportunity to be heard or was indicative of a preconceived outcome. An analysis of all the applicable evidence demonstrates that the petitioner was accorded all the procedural safeguards necessary for a fair hearing, including the opportunity to present evidence, respond to both allegations as well as questions from the senators, oppose the county assembly's position, and make a final statement. Excuse me. The Senate proceedings followed standard parliamentary procedure, incorporating an opening statement, presentation of evidence, an opportunity for senators to ask questions, and a closing statement. The court has assessed the totality of the impeachment process and found that the petitioner was given ample opportunity to present her case and respond to allegations leveled against her. While the petitioner has pointed out certain aspects of the proceedings that she considers unfair, such as limited debate time, the opportunity to make a personal statement, the alleged chaotic nature of the proceedings, the timing of official communications, and the perceived haste in concluding the impeachment, none of these claims have been substantiated sufficiently to warrant a finding that her fair hearing rights were violated. Therefore, the Senate's impeachment process was procedurally sound and does not warrant judicial intervention on grounds of unfair hearing. Conclusion. Paragraph 133. Gubernatorial impeachment is an invaluable safeguard against impunity and abuse of office that must be jealously protected. It must not be allowed to become an avenue for fighting political proxy wars or resurrecting the ballot box contestations that were determined by the electorate when it chose a particular candidate to hold the office of governor. In that regard, the Senate, as a national legislative body that is able to rise above the din of the county-level gladiatorial arena, is uniquely placed to safeguard the sanctity, probity, and vitality of this very important accountability measure. Watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. Interventions by the courts come further down the impeachment path, and thus it is the duty of the primary duty bearers, the concerned county assembly and thereafter the Senate, to ensure that impeachment remains as constitutionally envisaged. Turning back to the present case, and in light of the foregoing, the inescapable conclusion is that the amended petition dated 23rd December 2024 has not met the required legal threshold for success. As outlined above, certain aspects of what was laid before this court and submitted on extensively by the parties has been reserved for determination in another forum, a situation occasioned by the petitioner's choice to split her grievances into two petitions pending before two different high court stations. What this court could safely determine without falling into sub judice was insufficiently articulated for finding in favor of the petitioner. While ordinarily courts would follow the event, in the circumstances of this matter, I am satisfied that it is fit, just, and proper that each party bears its own costs. Before I rest my quill by penning the disposition and final orders, I must thank the learned counsel for the parties in this matter for their industry, adherence to strict and short timelines, and the professional courtesy they extended each other. The breadth of their written submissions and the manner in which they ably highlighted those submissions orally made this court's task of judgment writing a lot easier. I would also like to thank the parties for maintaining decorum while attending court sessions, despite this being a highly emotive and charged matter. Disposition and final orders. Consequently, and for the following reasons, this court finds and determines that A. The amended petition dated 23rd December 2024, which is the subject of the proceedings herein, is found to be without merit and is dismissed accordingly. B. The Gazette Notice number 10351, volume CXXV1, number 130, dated 20th August, published on 21st August 2024, and issued by the respondent communicating the decision and or resolution of the Senate to remove the petitioner from office as the governor of Meru County by way of impeachment is affirmed for the purposes of these proceedings. C. Consequent to A and B above, the subsequent constitutional and statutory actions are free to take place as per the applicable timelines. And D. Each party shall bear their own costs. Dated, signed, and delivered in open court on this 14th day of March, 2025. I did, before Councillor Mutuma, before you speak, I did state at the beginning that I would give you hard copies. As I was reading through, I saw one or two spelling mistakes, little double words. I will work on those. It will be uploaded into CTS. You'll have it today. So I'll do that. You'll have it on CTS today. I have signed the hard copy as required by the law with my handwritten corrections of those spelling mistakes. Yes, Councillor Mutuma?
Yes, thank you, Your Lordship, for the judgment. We note the expedition nature in which the court has been able to dispose of this matter.
Yes.
My instructions, Your Lordship, is that we note from your judgment that a majority of the issues raised in the petition remain unresolved
Yes.
and have been shelved and reserved for determination by the petition pending in Meru.
Yes.
We are therefore of a strong position that there is need to grant the petitioner an opportunity to have those issues which are the majority heard and determined.
Yes.
And since the court has had the opportunity to hear the issues being canvassed by all parties extensively,
Yes.
it will then appreciate the need for the issues, for the very weighty issues, to be determined.
Yes.
As such, Your Lordship, my instructions are to humbly request you to grant us temporary relief in whatever nature, but specifically an order of status quo to be maintained
Yes.
in the prevailing period, A, to allow the petitioner ably prosecute the issues pending before the Meru court,
Yes.
and secondly, to also consider exercising a right of appeal in the Court of Appeal.
Yes.
This order of status quo, Your Lordship, can be structured in such a manner that it will be time-bound, with the effect of automatically lapsing should the petitioner not have gotten a relief either from the Meru court or from the Court of Appeal. We submit, Your Lordship, that there will be absolutely no prejudice on any of the parties
Yes.
if orders of status quo are maintained. In any case, it is the situation that has been prevailing since August 2024.